court ruled, I'm quoting, objections based on extraterritoriality, political questions, and not justiciability will not be heard. Furthermore, the doors of the court are always open. Israeli soldiers are obliged to comply with Israeli laws and norms even when they operate outside Israeli territory. It's something that we can be proud of. In the field of supervision of armed forces, Israel has, I believe, taken legal measures that, to the best of my knowledge, no other state has done so. The actual combat activities as regards civilians, enemy civilians, are subject to real-time supervision by Israel's High Court. In one case, the question was, do we have to supply water and electricity to the civilian enemies? And the court ruled that the purpose of this petition is to direct the present actions of the military. This is ex ante judicial review exercised while military operations are currently underway. I know of no other country that does this. In the same case, by the way, Justice Benish said, judicial review during active combat brings the court closer to the zone of combat. These constraints do not deter the court from exercising judicial review in real time and handing down orders. These are difficult in the current circumstances, and continuing the quote, where terrorists cynically exploit that population for their own purpose. Nevertheless, this reality is the reality in which the military commander must satisfy his humanitarian obligations. Israeli courts are authorized to ensure that our soldiers, and I'm proud they do, behave in accordance with the law of war. I think it's a remarkable record for a state that has been practically in a state of war since 1948. Furthermore, we're doing it when most of our enemies openly flout these rules. We are facing terrorists whose very goal is to kill civilians. That's their objective. Nevertheless, I think we should be proud of it. Our soldiers aim at combatants, not at civilians. In one case, we found they were using ambulances to transport explosives. The question was, should we attack the ambulances? Not an easy question. The court and the army complied our combat forces are required to abide by the rules of humanitarian law regarding the care of the wounded, the ill, and the bodies of the deceased. This stance is required not only under the rules of international law, but also in the light of the values of the State of Israel as a Jewish and democratic state. Facing these sort of killers, nevertheless, we prosecute a soldier who violates these rules. I think it's in keeping with Jewish tradition, and I think we should be proud to belong to such a society. The irony, of course, is that Israel's record, unprecedented, of impartial judicial supervision of military activities is recognized by courts throughout the world, by academic writers, and of course has been totally ignored by the UN human rights bodies. On other issues, the Israeli court has waived the requirement, which exists under common law and US law as well, that an applicant must have a personal standing in an issue. Many of the petitions have been submitted by NGOs, Israeli NGOs, and this has allowed the court to deal with issues of principle. I believe that NGOs are granted by this freedom of application a status that no other state, as far as I know, allows NGOs. This, of course, is completely ignored by the UN human rights machinery. Another issue I want to, and it's not an easy issue, is the issue of torture. The question is, can you torture somebody if it's going to save human lives? Again, not an easy question. Obviously, torture is illegal, but what happens if you're going to, by doing it, should you do it in order to save human lives? And here the court deliberated, and its decision was that the rule, I'm quoting, the rules pertaining to investigation are important to a democratic state. They reflect its character. An illegal investigation harms the suspect's human dignity. It equally harms society's fabric. A reasonable investigation is necessarily one free of torture, free of cruel, inhuman treatment, and free of any degrading contact whatsoever. Human dignity includes the dignity of the suspect being interrogated. These prohibitions are absolute. There are no exceptions to them, and there's no room for balancing. neither the government, nor the head of the security service have the authority to establish directives regarding the use of physical means during torture. And the court added, we, however, are part of Israeli society. Its problems are known to us, and we live its history. We are not isolated in an ivory tower. We live the life of this country. We are aware of the harsh reality of terrorism in which we are at times immersed. The possibility that this decision will hamper the ability to properly deal with terrorists and terrorism disturbs us. We, however, are judges. In Hebrew, yesh shoftim b'Yerushalayim. There are judges in Jerusalem. We allow an issue which I know is prevalent here is, can you prosecute somebody on the basis of a secret document? And here it was the Israeli, not the courts, but the government, the Knesset, which said no. If a document is so secret that it cannot be produced, therefore the prosecutor will have to decide either to drop the prosecution or prosecute without it. But there can be no conviction on the basis of secret documents. Even on the controversial subject of the application of the Fourth Geneva Convention, and this is the last human rights issue that I want to take up, Israel has set a precedent that if it were not Israel, if it was some other country, it would have been held by international society. Why? Israel's legal position has always been that the legal status, Judea and Samaria, the West Bank, is in dispute and should be settled by negotiations. In Israel's opinion, we did not, in 1967, capture the territory of a foreign state, which is the criterion for applying the Geneva Convention. Nevertheless, what did we do? We decided to grant the civilian population all the rights that they would be entitled to if the Fourth Geneva Convention would apply. In other words, what we said is, this is not the territory of a foreign state we've occupied. Nevertheless, you will have all the rights. This, frankly, should be a precedent for other countries which might find itself in a situation where they're controlling a territory to which they feel they have a right of claim of right, not occupied territory, nevertheless the population that are not its civilians. Has this been recognized by the international world? Again, by legal writers, yes, but completely ignored by the UN human rights machinery. Because what does it do? It provides human rights, but it doesn't satisfy their political desire to castigate Israel. They're not, the human rights bodies, frankly, I don't think are interested in the human rights of the population. They want to make political statements. Therefore, we've been criticized for not legally applying it, because, again, we don't feel that legally it does apply, but there's not been a single mention in the 40 years of UN resolutions the fact that Israel has voluntarily, unilaterally applied all the rules of the Fourth Geneva Convention to the population. Not a single mention. Death penalty, I know you may have different opinions on death penalty, but it's interesting that Israel does not have a death penalty. If somebody fights us, he's got a good chance of being killed. But once he's surrendered, he's captured, we will not execute him. All of our neighbors, without exception, happily and merrily hang people. We in Israel will continue upholding human rights, not because we are instructed to do so by the UN, but because of the nature of our Jewish Israeli society. It is, however, galling to be continually castigated for not upholding them. As the English might ungrammatically say, it ain't fair. Thank you.